Good morning. First, just preliminarily, it's good to be back at Penn Law, from where I amazingly graduated 14 years ago. It's also always humbling not only to be on a panel with people who are far brainier than I am, but also with former classmates like Andrew Ferguson, whose outlines I relied on to graduate from Penn Law, and professors like David Rudofsky, for whose class I did not perform as well as I wish I had. It's also a little bit ironic that I'm on a panel or in a conference that has the words statistics and technology. But with that ringing endorsement, I want to talk a little bit. I'm going to talk in the pre-trial context about risk assessments. And I wanted to say also preliminarily that the ACLU at this point nationally does not have what I would call a firm position yet on the use of pre-trial risk assessment tools. We have some concerns which I want to highlight, but I'd say the jury is still out. One of the reasons that we are open to these, however, to some extent, is that I don't think the jury is still out on the fact, as has been referred to a little bit, and we were going to talk about, I think Sonia's going to talk about for a second, is that we don't think the status quo is working when it comes to pretrial detention and why and how people are detained. As many of you probably know, we have about 750,000 people who are in jail on any given day in this country, about 70% of whom are unconvicted. That population alone, I think, would give us something like the third largest prison population in the world. Many of those people are there simply because they are too poor to post bail. And so we incarcerate way too many people pre-trial than we should. So whatever it is that we have been doing over the last 10, 20, 30 years isn't working, and we should change it. So the idea of bringing in some sort of potentially evidence-based, more objective risk assessment to those decisions would be welcome if they work. I'd also note that we have affiliates, like our New Jersey affiliate, who are endorsing reform to pretrial determinations and are currently, following the passage of legislation in New Jersey, creating risk assessment tools that they think will significantly lower the pretrial jail population and allow many people out who shouldn't be in and only hold people in who should be there. The jury is overall still out on that. The reason that we have concerns, and by the way, I apologize, because I'm a technophobe, I'm also not using a PowerPoint. The reason we have concerns is in part, and folks here can talk more about this than I can, but data is inherently subjective. And when it comes to pretrial, really a lot of these risk assessment tools, and certainly pretrial tools, it seems all of them include criminal history, past criminal convictions, sometimes arrests, in terms of trying to determine who's going to commit future crime. And that data is inherently subjective because it is based on discretionary decisions that our criminal justice system makes every day, and those are infused with bias. These are decisions about, mostly by police departments, about where to deploy their resources, whom to stop, whom to arrest, whom to charge, and certainly by prosecutors, again, whom to charge for what, whom to seek bail and pretrial detention about. And so you are dealing with a data set that seems quite contaminated. It's also true when it comes to crime that we really don't understand or know the universe of crime that is committed. There's a great deal of crime that is unreported, far more than you may imagine. And so you are also dealing with an incomplete data set. And so you are making predictive decisions that are not only infused with bias, but also from a data set that really you don't know the full extent of. In terms of abuse of discretion, I'm just going to talk a little bit. Sorry, being tall is good in some ways. I want to talk, this audience will probably know a bit about this, but in terms of the abuse of discretion, the ACLU has spent a lot of time looking at the ways in which police particularly make decisions based on race. I think you know that there has been a lot of litigation and exposure of stop and frisk around the country, particularly in New York, where 4.4 million people had been stopped over an 8-year period, 83% of whom were black or Hispanic. Most of those, 90%, did not result in any further law enforcement action. Only 10% of those stops were of white people. Here in Philadelphia, we saw similar patterns. Both those cases led to litigation challenging stop and frisk practices. Professor Radowski is lead counsel on one of those cases. We have seen similar patterns in Illinois, where our affiliate documented widespread racial disparities in who is stopped, in Boston, in Miami Gardens, and the DOJ's report in Ferguson. All across the country, you are much more likely to be stopped and searched if you are a person of color. We've also documented such disparities when it comes to arrests. We put out a report on marijuana arrests a few years ago, a national report documenting that over a 10-year period from 2001 to 2010, blacks were over 4 times as likely to be arrested for marijuana possession than whites, notwithstanding comparable usage rates. We found that in some states it was 6 to 8 times as likely, some counties 15 to 20 times as likely. We put out a report recently in Minneapolis showing that blacks were 8 times more likely to be arrested for vagrancy, 9 times more likely for disorderly conduct, 12 times more likely for marijuana, and 17 times more likely for curfew and loitering violations. We documented this in cities throughout New Jersey. We just put out a report in Tampa showing that blacks were twice as likely to be summoned for seatbelt violations. And so we know that when it comes to what kind of data you're relying on in terms of past criminal conduct, what you're really measuring is past police behavior more than you are who and where crime is being committed. I have a couple examples. I was a public defender in the South Bronx for a while, and I'll just give you 2 examples. I had a 17-year-old kid who used his Metro card, which is a school Metro card, on Election Day. And for that, he was arrested, spent 24 hours in jail. That is not something that would happen to a white kid in New York. I had a 47-year-old woman who switched subway cars while the train was in motion, which wasn't a crime when I was a kid in New York, but apparently was later on, because a man was making her uncomfortable. She was arrested and spent 24 hours in jail for that. That kind of criminalization and targeting happens all around this country and would seem to significantly distort crime data that we're relying on to make predictive decisions about who's going to commit crime. I also wanted to make the point that this is something that has been woven and done throughout history. I read a book a couple years ago called Slavery by Another Name by Douglas Blackman about the re-enslavement of black Americans after the Civil War. And he starts that off with a story about a guy named Green Cottingham in Alabama who was arrested for vagrancy. And he talks about how vagrancy was a crime that was really concocted from legal obscurity, and then it's the crime of not having a job. And when, at a time when there was massive unemployment throughout the South among whites and blacks, it was used exclusively to criminalize unemployed black men. And so Green Cottingham's offense really was blackness. And that was in 1908. And we see a lot of that today when you look at the data. So again, our concern is that risk assessment models are fundamentally biased, not because of who's necessarily committing the crime or who's at risk of committing crime, but who's at risk of getting caught, and fundamentally biased because of the structure of policing and of our criminal justice system, which is inherently biased. There's also a lack of representation because of this myopic focus on race when it comes to criminal activity. In the first few pages of his book, The Condemnation of Blackness by Khalil Gibran Muhammad, he says, in all manner of conversations about race, from debates about parenting to education to urban life, black crime statistics are ubiquitous. By the same token, white crime statistics are virtually invisible, except when used to dramatize the excessive criminality of African Americans. Although the statistical language of black criminality often means different things to different people, it is the glue that binds race to crime as it has in the past. And so while I think, Sonia mentioned that race isn't actually put in risk assessment tools, that's not a factor that is ostensibly considered, it seems like it is dripping with race. When it is involved, when you're looking at things like not only some of the socioeconomic issues, but also when you're looking at criminal records. And so in a sense, it seems like race very much is part of the variables, and that needs to be discussed. And so our fear is that we're going to use statistics and data that is contaminated to further sanitize racial injustice and justify continued disparate treatment. Got a little more time. I then wanted to just flag, and these are maybe things we can talk about more, which is less, I guess, a data concern than it is an administration concern. Some things with risk assessment tools that we're very concerned about. One is, while we definitely want to lower the pretrial jail population, again, that doesn't need to be there, we are concerned that we're going to move into a regime of what I would call non-incarceration restraint on liberty, the over-supervision of people who don't need to be supervised. And there have been studies that show that when lower-risk defendants get out, according to risk assessment models, they're often over-supervised, and it's more likely that they're going to then fail and end up back in jail because of that over-supervision. And so if we just succeed in moving people from jail to this kind of over-supervised restraint of liberty world, often defined by race and class, I don't think that's a significant enough victory. A couple other things that we're concerned about. One is the use of, if you're going to have risk assessment tools and you're going to release more people, hopefully, you do need to have robust pretrial services, which a lot of places do not have. Something that often steps in place of those are private probation companies, which we see in the post-conviction context, but we also see in the pretrial services. Private probation companies charge people for those probation services, saddle them with debt. They often then end up failing to pay and back up in prison. And so that is another concern we have. I'm also concerned that when you have risk assessment tools, it often allows for the alternative to allowing somebody out is preventative detention. And even though we have a form of that today with the abuse of money bail, if somebody scores, let's say, 2 on a scale of 2 or 3 on a scale of 10 for risk of future violent crime, or 4 or 5 on a scale of 10 for risk of future crime generally, even if that actual risk is fairly small as a percentage, is that going to result in more preventative detention than we currently have today? A couple other quick things is, if you're going to have risk assessment tools, and this is true for bail generally, pretrial generally, you want and need lawyers there to argue, what does this score really mean? And what is not included in this score? What can I tell you about my client that you can't just tell from a number? And throughout the country, to my shock, really, when I started doing pretrial justice work at the ACLU, lawyers are absent in a lot of courts, pretrial courts. They're not present at a lot of bail hearings. They're not there to make appeal bail decisions. And so another fear is that you're going to have judges using risk assessment tools without the input of advocates. The last thing, two other quick things. One is we're concerned with how these risk assessment tools are going to be used in terms of the determinations by judges and prosecutors beyond the pretrial release decision. So there's sentencing, but what about in future cases? What about other agencies? If they get, how private will these be, and how can this information be used to continue to discriminate people in other contexts if they're deemed high risk for future criminality? And the last thing is, I'm always concerned that we're not including the communities most directly affected in this discussion. What is their feeling about risk assessment tools? James Baldwin said in 1972, if one really wishes to know how justice is administered in this country, you don't question the policemen and the lawyers, the judges, and the protected middle class. You go to the unprotected, those who need the protection most, and listen to their testimony. And I feel like that is not something that is happening when we're talking about assessing individuals and communities for their risk of criminality. Thanks.